The broadcast is now starting. All attendees are in listen-only mode.
Hello, welcome. My name is Robin Kincaid. I'm from Nevada PEP, and I want to welcome you today to our webinar. Nevada PEP is a parent training and information center here in Nevada, and we cover the entire state of Nevada. We want to welcome you to the webinar, Behavior and Discipline in School. Thanks for joining us. Right now on our screen, you should be able to see more information about Nevada PEP. There is a slideshow that's kind of going through talking about the Parent Center and how we help families with children with disabilities. Behavior and discipline can be a very stressful time for a family. When families find out that their child has broken the rules and is subject to discipline, often they're feeling very concerned about what's going to happen next. So we're really hoping that the webinar is going to help you learn a little bit more about the processes that are set up for students with disabilities. And we want to keep reminding you that you have rights, you have procedural safeguards, and that you have the ability to challenge decisions that might be made regarding behavior and discipline. Feel free to ask questions in our question panel. We look forward to answering them right here live and are happy. I got the panel open, so if you have a question, feel free to type that in and we'll get you an answer right away. So once again, thank you for joining us, and we do really hope that this information is going to be helpful, but we also want to remind you that Nevada PEP is available either online or through the phone, or even families that walk in to provide more information. Of all of the topics that we talk about at Nevada PEP, when families are calling regarding a behavior or discipline issue, they are probably at the height of their stress. They're very concerned about their children. They don't really understand what the next step is and what the school's going to do. They may even feel as though that the charge that their child violated rules or broke rules is either unfair or not even accurate. So I think that sometimes that can increase the level of stress and have families very concerned. So we're going to go to the curriculum now. You should be able to download those handouts right there on your computer so you can follow along with these slides. So if you'll bear with me just a moment, we're going to stop showing the screen. We'll come back to the slides and put those up right now. Okay. So what you should be able to see now would be our welcome and the title, Discipline and Behavior in Schools. So the curriculum was developed by actually the Pacer Center, and it was adapted to include the Nevada Administrative Code regulations. And we also do some work at Nevada PEP on positive behavioral supports. And that's really the foundation for applying discipline in schools. So I want to continue to go back to positive behavioral supports and interventions. There's also a Dear Colleague letter that the U.S. Department of Education released back on August 1st of 2016 as guidance that really stresses the importance of using positive behavioral interventions and supports. Okay, I just want to double check that audio. Yeah, it looks like the audio is coming through. Great. So let's kind of go through a little bit of our agenda here that we're going to talk about in this next hour. Really want to make sure that we talk about the student code of conduct. We want to talk about what also might be termed in some parts of the state as RPCs. Often families hear that acronym and not sure exactly what it means. It's required parent conference is what RPC stands for. But we also talk about suspensions and pending expulsions. Manifestations determinations are often really confusing to families. The functional behavioral assessments and back to positive behavioral interventions, I want to talk about how that plays a role and that families may want to ask about functional behavioral assessments and also be knowledgeable if their child currently has a behavior intervention plan or if the school needs to develop one. Change of placement and interim alternative educational settings are also sometimes confusing terms for families because they're just not familiar with the fact that students with disabilities have to receive education, that there are only these 10 days that the school cannot provide this. They must continue to provide free and appropriate public education. And then, of course, what are their appeals? And then we want to touch in on physical discipline. So the quote here, I suppose it's tempting, if the only tool you have is a hammer, to treat everything as if it were a nail. And sometimes I guess what we're trying to say here is that often we continue to do the same approach, and service for children with disabilities must be unique and to them. In other words, they have to be individualized and they have to be unique. So not every situation we can apply the same either discipline or the same response. So we want to make sure that we have a tendency to approach behavior and discipline always in the same way, worrying about being maybe fair, but we forget we have to individualize our approach for every student. So this is just kind of a reminder of that. So let's talk about the day that often parents get that phone call when the student violates what we call the code of conduct. Children do get information and guidelines, and quite frequently teachers and administrators go over the rules, and there is an expectation that kids are going to understand what those rules are, but when they're violated, the Individual Disability Education Act addresses the extent to which the schools can take disciplinary action when a child with a disability violates the code of conduct. So, as you see in the question there, can you think of any school policies a child with a disability might violate? Well, one of them comes to mind right now as I think about it is the fact that sometimes you have schools that say, well, we don't allow any water bottles. And so the child takes water to school, and that just might be the rule, that we don't allow that. Other things, I was reviewing a policy last night that a school just implemented on absences. And it says very clearly in their rules that children can't turn in absent notes later than 3 days. But students with disabilities certainly might not be held to that standard if their disability would affect them from being able to turn in a school note, or they continue to have absences that need to be excused. So sometimes the school policy can't override what's already in the IEP, but that's why many times Nevada PEP is encouraging families to be specific in the IEP, write in accommodations that the child needs, be aware of how the rules could impact the child and where we might run into some difficulties in the student being able to follow the rules and still be able to receive free and appropriate public education. Okay, this next section. So we want to remind you that no student can be suspended, expelled, or excluded except when it's in compliance with IDEA and the Nevada Administrative Code. So when parents and schools discuss behavioral consequences, they need to consider like all the information relevant to the behavior, including evaluations and diagnostic results, observations, the student's IEP and placement, not just maybe school behavioral reports and summaries. So we want them to look at all of the information. For example, if a student might be eligible under one eligibility category, but might have multiple types of diagnostic information, or in the child's file might contain information that's relevant. Sometimes kids with disabilities, we kind of know them as a child, for example, that has like a learning disability, but we forget that the child's had maybe a history of having attention difficulties, and some of that attention difficulties often results in the student have maybe some impulsive behavior or having poor judgment. So those are factors that would need to be brought up and discussed by the family so that they could talk about the discipline action and get kind of ready to start this manifestation process that will have to be done if the child is out more than 10 days in a school year. Let's get to that slide. If they're removed now to up to 10 days, those are what we might call free days that the school could not provide services. So 10 days per school year is the max amount of time that the student could be out without receiving services. And there'd be no manifestation up to the 10 days. As a reminder, any portion of that day is counted as one day. Transportation also could be part of that conversation. The bus suspension would be treated as a suspension unless the school provided another way for the child to get to school. Once again, that question pane is open. We would encourage you to feel free to type in questions, checking it again to see if we need to stop and address a question. So now we've kind of covered up to the 10 days. And certainly parents could pick up homework. They could do what they can to try to make up for the missing instruction, but the school is not obligated to provide an alternative instructional arrangement for the period of up to 10 days. Now we're at 10 days. Things have changed. And so we're moving toward that 11th day. And so the school would need to schedule a manifestation determination, because remember, the student is entitled to free and appropriate public education. So once they're out for the 10 days, it's really considered a change of placement as well. So they must agree to meet so that there can be some discussion, and the school district would be required to give a prior written notice regarding their intention to suspend the child up to beyond the 10 days, as well as do the manifestation and a meeting notice. So parents have to be notified, as I mentioned a moment ago, in that prior written notice. And the parents must receive their parental safeguards notice, which is important. to know what their options are if they disagree with any decisions that might be made going forward. So let's talk about that manifestation of determination meeting that begins. So the school team the IEP team, which again has to consist of required members, special ed teacher, regular ed teacher, and someone from the school that acts as a LEA, the educational authority, local educational authority person. That person then would conduct the meeting and they talk about what are the charges. So what is the violation of code conduct that the student did? They'd present and they'd review information. They might be possibly looking at what we call redacted statements, which are statements that may have other students' names blacked out. They're going to look at teacher information. They also might be talking a little bit about how the student's been doing overall. Was this an isolated incident? Was this a chronic issue? What kinds of information would be relevant to the child's overall condition? An example might be if the child did not take his medication, or if the child had some traumatic event that occurred, say, on the weekend, and then the incident occurred on Monday. If the child was just released from a hospital, whether it be a medical or psychiatric hospital. The parents would have the opportunity to present, the information, their understanding. If there was bullying as part of this, that would also need to be part of the conversation as well. So parents want to prepare. They want to get prepared for the information. They want to talk about how they see this happening and how, their son's version or their daughter's version of the situation. So they want to give the child's perspective. They also want to talk about perhaps things that maybe were not implemented in the IEP. Maybe the child was in the wrong classroom. Maybe the aide that was supposed to support the child wasn't there. So that's all a part of that preparation. Parents may want to bring a support person or an advocate to help them through that, because it may not feel like the routine IEP meeting, because of the fact that we're mainly talking about an incident and how does it relate to the child's disability, as well as we're talking about was the IEP actually implemented. So those are two questions that families might not feel comfortable doing that without support or an advocate. The IEP process typically flows the same way every year. This could be something very new to families. That's another reason why it's so stressful. Okay, so they're collecting and examining all these records for the current IEP, and they're looking for a pattern of behaviors. They're also going to go back and take a look at that behavior plan. Was the behavior plan implemented the day of the incident, when the incident occurred? May talk about child's grades, or how is the child doing in class during the week. In other words, if the incident occurred on Friday, was there a build-up Monday through Thursday toward the situation? Certainly families could provide information about home behavior concerns. Let's just say that the child had run away on Tuesday and the incident occurred on Friday. There could be some relationship to some problems where the child is upset with something going on at the home. They also might interview the student. Parents can decide whether they want the student to attend this meeting or not. It is a parent decision. Often, students that may be struggling with behavior also have a very heightened sense of unfairness. So they could perceive this whole process as being either unfair, and besides, they're a student, and often there's at least 6, 7 adults in the room talking about their behavior. So parents would really want to kind of think about whether or not it's a good idea to have the student present, because getting the student's input in writing, even taping what the student believes happened, or for example, if the student feels like they were just defending themselves, or if the student feels like that they were in danger or safety, all of that would be relevant information. Of course, in the last one, they were talking about the nurse identifying medical side effects and behaviors, and also, of course, the teacher talking about maybe a certain kind of day the child doesn't do well. So maybe this particular episode happened just before lunch, and could hunger have been a factor? Could the child's blood sugar have been dropped low? So often things are not just the reports that we get from the school. We have to look at a bigger picture to kind of find out what happened and how we can respond to that. Once again, we have that question pane open. Let's go to the next slide and talk about that. So this we want to interview administrators, kind of how did they see what happened. For example, if the child was restrained, was there paperwork generated to explain the restraint and how long it was? And we also want to think about, is a child in the right program or placement? Is that child appropriate in where they're at? And was the fact that they were, for example, in self-contained actually a contributing factor? So would they be better off in general ed because they wouldn't be necessarily feeding off some behaviors that are occurring in a self-contained classroom? We want to consider the characteristics of all the child's disabilities. Once again, if a child has attention issues, is it a situation where that child has either a heightened sense of unfairness, some judgment issues, some impulsivity? Is a child overly immature? And does a child very young in his grade? So a child that has a birthday just prior to the cutoff in October can be the youngest student in his class until he reaches that age that he's supposed to be. So sometimes it can run young all year. Consider, of course, those cognitive, emotional, and behavioral status. We're going to talk about when are we going to do a functional behavioral assessment and how recently have we ever done one. And of course, are we implementing positive behavioral support plans? We're going to review and modify existing behavior plans. So this is one of the questions that we're talking about here. Actually, the two questions. Let's go with the first one. Was the behavior caused by, or was it in direct and substantial relationship to the child's disability? So we're just kind of like, let's just think about that question right now. So was the behavior caused by, or was it in direct and substantial relationship to the child's disability? So even though the child might have a learning disability, since we've taken a bigger picture and really looked more carefully at what the child's disabilities are and looked in the file, do we see something in there that would help us relate or find a connection to the incident? If the answer is yes, then all discipline stops. Let's just say, for the sake of having this conversation, if number one is no, then we need to go to the next question. The next question is, did the behavior occur because of a direct result of the LEA or the school failure to implement the IEP? If the answer is yes, once again, all discipline stops. So we only need a yes in either question. but we will probably go through the motions of asking that. Now, sometimes families say, yes, the school did not implement, he didn't get his accommodations, or he was put in the wrong class. He was supposed to be in a resource and he was put in regular ed. So those are questions that often are discussed prior to this meeting with advocates and others that might be supporting the family, but the family wants to be prepared for these two questions and be able to have a discussion about how there is a relationship between the child's disability and the behavior, or there is a concern that the IEP was not implemented. Oh, top comes up here, the two questions. Okay. So again, if it was the behavior was a manifestation of the child's disability, then the team is need to do the following things here. They have to talk about the behavior intervention plan. Also, if the behavior intervention plan was not implemented, that would also be a reason to stop the discipline. We also want to make sure the child gets returned to their previous placement. And if the school and the parents agree, we want to change that placement as part of, modifying the behavior intervention plan. And again, if we need a functional behavioral assessment, this would be the time to talk about doing that. But you might like to see our little humor here. Says the principal suspended me. School is the only place in the world where you get time off for bad behavior. So often that is the case. And sometimes we find that students respond to, I think I really would like to spend the day with mom, so I think I will be rude to the teacher, or maybe I can get suspended. There can be situations, though, where students maybe have been threatened by another student, and they will do ACT UP just to be able to be sent home so they don't have to face the consequences of that student. So the functional behavioral assessment focuses on identifying the function and the purpose behind the child's behavior. So we have to observe closely on the behaviors and the environments the behaviors are happening. So we want to know, is it unstructured settings, what time of day it is, what are the antecedents, what happens prior to the behavior. Is a student feeling like they're in a fight or flight kind of situation? Are they not feeling as though they have choices? Do they feel as though that they are unfairly being selected for behaviors? So in other words, something happened in the classroom, the teacher says, well, it's always that kid. So there's lots of things that we want to do to make sure that students with disabilities understand how their behavior affects others and how we can help shape behavior. But we often have to understand what the antecedent was. These are some characteristics of a positive behavioral intervention plan. So sometimes we make changes in the environment. So like, for example, we might put the child in a different part of the classroom, or we might offer the student an opportunity to go into another area temporarily to calm down or de-escalate. And then we want to make sure that if we kind of work on a replacement behavior, that it can serve the same function for the student. So if the student is having difficulty sitting still and is really struggling because he wants to move his fingers all the time, but he's been tapping a pencil on the desk, and that's just really disrupting other students' learning, we might be giving him a replacement item that wouldn't be so disruptive. Of course, we want to work on those skills training for the student to use. We want to reinforce when the student is doing what we want him to do. We might want to make sure the routines are very clear to the student and what options the student has if something upsets him. So when the teacher hands back a paper that has an F on it, how's the student going to respond to that? So we have to practice his response that would be more appropriate, which we certainly want him to say is like, what did I get wrong? Or, what happened here? Instead of just yelling and screaming, this class isn't fair. You're not teaching me, that kind of thing. Also, of course, the self-management strategies. So we want to make sure that we're clear that behavior intervention plans are about teaching, and those are proactive. Discipline plans should not be in existence, and those are more reactive kind of situations. So proactive positive behavior intervention plans are really important, and certainly we want those instead of any kind of discipline plan. We also want to make sure that we're clear about the behaviors that are related to the child's disability. So when we do the IEP, in the special factors, the first question on the special factors is does the child's behavior interfere with the learning or the learning of others? So if that case, we must use positive behavioral supports and interventions. So it's required to do that on a regular basis to look at IEP team is required to figure out what kind of interventions does a student need. Nevada PEP has an accommodation modification list that we're always so happy to share with families that might give them some ideas on accommodations that might help that child be able to do better at school. Kind of want to just take a moment to address students that have emotional or behavioral problems and ask some questions. So we want to make sure that we include any mental health services they might need and whether or not we are addressing their mental health needs and recognizing that even though we know that they may have some learning difficulties, are we teaching the appropriate behavior and social skills as well as addressing their academic difficulties? Sometimes families struggle with the idea that I don't know whether or not my son doesn't do well in school, which causes him to have behaviors, or he has behaviors that are not necessarily related to his performance academically. Sometimes that's not always clear to the families or even the school or the student. So earlier we talked about the manifestation. It was not, in this case, we're saying it might not have been related to the student's disability, and when we believe the IEP was implemented. So at that point, the student could be subject to discipline, but they certainly could file and use their procedural safeguards and their rights to ask for like an expedited hearing to make sure that a hearing officer looks at the situation and helps decide whether or not the school's position and that the school feels as though that it was not a direct result to the disability and the IEP was implemented. So again, that could go back to a hearing officer, and the parents have the right to challenge that in a due process hearing, and they usually are expedited because discipline are typically expedited hearings. So just as a reminder, punishment, may teach the individual what not to do, but it doesn't teach the student what to do. So we want to make sure that whatever changes we make are very positive strategies so that can modify the environment and so that we don't see a reoccurrence of these behaviors. And of course, we're teaching replacement skills. We want to increase the independence of the student. We want to recognize that once a student, say, leaves school, does he have the skills and the self-control to be able to not react or overreact to situations, whether he's in 7-Eleven or he's in a restaurant and something happens. Can he have the self-control? Does he have the self-talk? What can he do to be able to control himself? Can he use deep breathing or count to 10 or other strategies or leave the area in order to be able to not escalate the situation? So remember, we want to be using positive behavioral interventions and supports far more often to teach kids what we want them to do than talking about either consequences or punishment. So this is kind of a scenario that's going to talk a little bit about a change of placement, because if we are considering sending a child to, for example, like a behavioral school, or we're saying the child has to be out, at home getting alternative instruction, we have to talk about how the law views a change of placement. So we want to talk about Jenna, who is suspended from school for 6 days in November and then another 3 days in February and a day in April. That doesn't constitute a change of placement because, again, it's under the 6 days, it's under the 10 days. But talking about Robert, the school could determine that the following removals, he's showing some impulsive type behaviors, and we could talk about how that could be related to his disability. There are some special circumstances, and the school could talk about removing a child with a disability if there were serious violations or circumstances related to the weapons, the drug offenses, or bodily injury upon another person at the school. So these are like case-by-case situations. The law says very clearly that we have to be considering unique circumstances on a case-by-case situation when we're determining whether there's a change of placement. Special circumstances, serious violations, but free and appropriate public education still continues. We'll talk a moment here about interim alternative placement settings and educational services. So let's talk about when services must be provided. Again, the 10 days kind of rules, but they must continue to provide services. So the idea says that after a child with disability has been removed from his or her current placement for 10 school days in the same school year, during any subsequent days of removal, the public agency must provide services to the extent required under 300.530. So they still are required to provide alternative instructional arrangements after these 10 days. And those could look like services that are maybe at the library or another neutral location. They could be services in the home. They would not necessarily be hour for hour, but typically we'd be talking about 1 or 2 hours for each day, and those could accumulate, and as students could tolerate, those could be provided in different ways. And there may be even some time to provide those services, but the goal is to keep the student caught up, continue teaching, and getting them to complete assignments. Oops. So again, kids that have been subject to disciplinary removal for drugs or serious bodily injury or weapons would probably be in an interim alternative placement setting unless the families would file a due process hearing. But they also would, in the meantime, we'd be doing a functional behavioral assessment, and we'd be looking at where the student would be returned. So the placements, they're either resolved or they expire, whichever occurs first. So the most that we probably see these would either the hearing would occur or if the 45 school days, would occur. Okay, so now parents could appeal and they could request a hearing. So they do not agree, so they're filing for a due process hearing. And the hearing officer would listen to all of the information from the school, and they would determine and do a review of whether the school's manifestation process was appropriate. They're also going to consider injury potential or placement risk, and does the temporary setting where they're getting the interim alternative services, does that meet the needs? So parents could request a hearing for determination whether the behavior is a manifestation, and also regarding the placement as well. So you can see some of these processes can take a little time. So kids can be out of school, but they are getting those interim services that should help keep them caught up. But it can be difficult, again, if we're trying to help kids learn skills that help them stay in school. Okay, so the school district or the state is responsible for arranging these expedited due process hearings. And then, of course, that officer needs to make a decision within the 10 days. That hearing comes up very quickly. There's also a resolution session that's held within 7 days of filing. And that resolution session, is an opportunity for both the school district and the parents to try to work out something. So it's a conversation to try to avoid turning it over to a hearing officer. So the school district often would want to try to come up with a solution, but if they're concerned about safety, then they may be reluctant to have the student come back until some additional information is available about how the student is going to not continue to violate the code of conduct. So here's the authority of that hearing officer. And they're going to decide whether the removal was appropriate, and whether the child's behavior was a manifestation of his disability, or whether or not the current placement is likely result to be a problem for other students or teachers. Certainly, the hearing officer decision can be appealed, yes. This is talking a little bit about the appealing the interim alternative placements. So again, if the time that the student's been out, the 45 school days, which is 2.5 months, then the student just goes back. But if the hearing officer is ruling any sooner than that, certainly if that comes first, the student goes back to the school. And there is placement during the appeals. And so the parents, if they feel like that they want to again appeal the pending hearing decision, they can continue to write up those appeals. Again, using their attorney to do that. The next section we're going to talk about is the safe and respectful learning environment. And lots of laws have occurred in the last, since 2015, regarding the bullying and the safe and respectful learning. So there's some new changes in the bullying that we just want to point out, that bullying can't be applied to students that are under kindergarten age. So 3 and 4-year-olds can't be charged with bullying. If a student with a disability is charged with bullying, there can be certainly a different review, and they may not be able to be charged with bullying if it's a person with a disability. So that could also impact, and we're trying to see kind of how that plays out. But the other thing is, if bullying has been substantiated, so if a child with a disability has been bullied and is a target of bullying, and that has been substantiated by the school, they could be in a situation where they're able to change schools. So once that paperwork comes back as substantiated, then the district must consider a different school if the parents request that. There's a lot of information now about what bullying is, cyberbullying, and of course there is the new app, Safe Voice, that allows parents to report bullying and other concerns about safety so that schools can respond to it. If parents disagree with the school's investigation, they have the right to appeal to the Nevada Department of Ed. And Nevada PEP has information about that, and we always welcome phone calls if there's concerns that they don't feel that either the bullying complaint was investigated or they don't agree with the outcome of the investigation. Okay, physical discipline against a child is our next conversation. We want to talk about, the idea of what corporal punishment is. There is a handout in your packet called Physical Discipline Against a Child with a Disability. Is it legal? So I would encourage you to look at that. If there's any concerns about a child receiving corporal punishment or physical discipline, it is against the law in Nevada. If children are restrained, there has to be documentation that explains how long that restraint occurred and the reasons behind it. Children should only be restrained if they're a danger to themselves or others. It's also against the law in Nevada to use adversives, and so this was regarding a bill that was passed in 1999. Parents would want to immediately talk with the administration of their child's school if they had any concerns about punishment of this that was being used on a person with a disability. can't spray water on kids, we can't use odors or blasts of air, or even pretend to hurt them. No. So parents can ask for a written report regarding the incident, and parents could attend a meeting as an observer. If the Board of Trustees has found that there to be a denial of rights, parents could contact the board member representing their area and provide additional information. There are some protections exceptions for non-identified students. So if parents have notified the school district that their child has a disability, maybe it's been diagnosed, and they've requested an evaluation, then the rights that would have kicked in if there was an issue with discipline. So the school could have deemed to have knowledge that the child has a disability, even if the school did not respond to a request for an evaluation or denied. There is prior knowledge. So certainly the rights that we talked about today could be effective for and be implemented for students that actually have not been found to be eligible, but the schools had knowledge that they had a disability. These are some of the ways that children are protected. They've expressed concern in writing to an administrator or a teacher, or they've requested this evaluation. It's important to keep records. If a parent does request an evaluation, we want to hold on to that letter, show it when it was provided to the school, because that was a notification that the parent provided. So I want to make sure that the records reflect. So if there is a discipline issue and the school says, well, we didn't know, well, you did know because we requested that evaluation. The school district cannot be deemed to have knowledge if the parent at that point refused to have the child evaluated, or they refused special education, or they did evaluate and they determined that the child did not meet the eligibility requirements in any of the 13 categories and did not result in receiving special education services. So then the school is not in a situation where they're deemed to have knowledge. Okay, so there's nothing in the law that would stop the school district from reporting a crime to the appropriate authorities. So that's just something parents should be aware of. If there is if something that might constitute a crime that has occurred during the violation of the code of conduct, the school district could report that. And so a student could also receive discipline or at the school, but also could have to work with the courts as well if it was an offense that would constitute a crime and that could be charged. And there could be copies of the special education and disciplinary records. So once again, we encourage you to contact Nevada PEP if you have questions about discipline, and if you feel as though that this particular topic is overwhelming and can be confusing. We would encourage you to participate in this process with the school and ask lots of questions. Please refer to our website, nvpep.org, to attend additional webinars or one of the classes at our centers. We would love to have you participate in that and learn more. You are your child's best advocate. And even though it can be difficult, and parents are always very concerned if their children have behavioral problems at school, we are here to support you in this process. We know it can be stressful. Many of the staff that work at Nevada PEP are also parents that have had situations with their own children and have had to work with the school to try to resolve discipline issues. So do not hesitate to give us a call. Do not hesitate to contact us online. Please visit our website for more information. And again, I'm going to once again check that question panel, and we're happy to answer questions. And I'm going to stay on for a couple more minutes to make sure that we get any questions that you might have addressed. Thank you again for being part of our webinar today, and have a wonderful day.